Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Labenz. Today we are going to talk about how to prepare for trial if you have a post-decree or post-order modification and/or enforcement case. So you've already gotten divorced or you've already established custody, and now your case has been set for a trial. First, we're going to talk about how to get your case set for trial if the court doesn't order it on its own. We'll talk about preparing your list of witnesses and exhibits, the notice of issues, the pretrial statement, your trial outline, and then how to do a notice of lodging and a proposed order if at the conclusion of the trial, the judge orders you to lodge a proposed order with the court's findings. First, let's look at how do you set a case for trial. This is under Rule 77. So the court could set a trial on its own. Often that happens at a resolution management conference. But if it doesn't happen at the resolution management conference, or the court hasn't just issued an order setting a trial and you want a trial set, then you can file a motion, and the motion must state the date by which you're going to be ready to go to trial, the names of the parties and their contact information or any attorneys that are involved, whether the case is entitled to preference for trial because legal decision-making or parenting time is at issue, and the estimated time that you want the court to set for the trial. This is Maricopa County's set form for the motion to set a trial. So you'll see here that all of the required information that we just talked about in the rule is here in this set template motion. So the date the case will be ready for trial, information about the parties and their contact information, whether or not the case has a preference for trial because legal decision-making and or parenting time is at issue, how much time you want the court to give for the trial, and then the mailing certificate you'd sign and you'd file this, mail a copy to the other side. Once your case is set for trial, you're going to want to look through all of the deadlines listed in the order setting trial. And you'll want to see if there's an order to file and or exchange a list of witnesses and exhibits. I've practiced law in several different counties, and not every county required this. I'm in Yavapai County right now, and Yavapai County does have us file these lists of witnesses and exhibits. So I'm going to show this to you. If it's ordered in your case, you'd file the list of witnesses and exhibits with the court prior to the trial by the deadline set by the court, and you provide a copy to the other side. So here's what the list of witnesses and exhibits form looks like. You'll fill out the parts in red. Here's where you'd list your witnesses. Now, if your only witness is yourself, that's what you'd list. If you want to potentially call the other party to the stand, you could list them as well, and then any other witnesses you have. And then you list out each exhibit that you plan to use at the trial. That would get filed with the court and a copy mailed to the other side. Now, there's also a requirement of this document called the Notice of Issues. This is under Rule 76.1F. There is a set form for this, which we'll go over in a minute. The Notice of Issues must contain a complete list of all remaining contested issues the filing party intends to present at the trial. Issues not raised previously cannot be raised for the first time in the Notice of Issues. Each party must file a separate Notice of Issues. Issues listed in the Notice of Issues are listed generally. Specificity is reserved for the pretrial statement after the parties and or their counsel, if represented, have met and conferred to narrow or resolve the contested issues before the generation and submission of the pretrial statement. Neither party is required to file a Notice of Issues before a temporary orders hearing or other interim hearing. So this applies to a final trial on the petition. And this is where you just list the contested issues in a general manner. And then in the pretrial statement is when you get into more detail. When do you file the Notice of Issues? It is due 20 days before trial. So you're going to want to calendar that deadline. And then your pretrial statement is due 5 business days before trial. So the 20 days before trial are 20 calendar days. And then the 5 business days before, or the 5 days before trial for the pretrial statement, are business days. So that means you don't only count days the court is open. You do not count holidays or weekends in calculating those 5 days. Here is the set form for the notice of issues. So you fill out your caption, indicate if you're the petitioner or the respondent, and the date and time of your trial. And then you're looking at here, we have modification or enforcement of legal decision-making, modification, enforcement of parenting time, modification or enforcement of child support, modification or enforcement of spousal maintenance, division of property or debts and assignment. Yeah, that's not going to apply. Modification or enforcement of an order dividing community property and or debts and or assigning, confirming separate property and debts, allocation of attorney's fees and costs. So you'll need to determine what is at issue in your case. Are you facing a parenting time modification case? In that case, you check here, check this box, modification of parenting time. If you've got a child support enforcement case, you check here, enforcement of child support related to the following minor children, list that out. If you're looking to modify spousal maintenance, modification of spousal maintenance, payments made by who's the paying party, who's the receiving party. So really just go through this document and check the boxes for what applies in your case, and then indicate what the disputed issues are related to each category. Let's see here, we've got a question. Modify and enforcement. Sure, you could check both if that's at issue. Yeah, you could have something to enforce unpaid child support and then also to modify it. And so you would just check both boxes and then write on the lines exactly what the issues are. Once you've completed this form, you'll date and sign, fill out the mailing certificate, and then file it with the court and send a copy to the other side. So that's the notice of issues. And then we've got the pretrial statement. So pretrial statements can be joint or separate. And you're going to see what the court orders. So unless the court orders otherwise, the parties may file joint or separate statements. If preparing a joint statement, the party who initiated the action set for hearing must take the lead to prepare a draft joint statement and must communicate with every other party concerning the statement as outlined below. So the party who initiated the action set for hearing must provide their outline for the pretrial statement to the opposing party 15 calendar days before the trial. Then 8 business days or more before the hearing, the parties must exchange their respective portions of the pretrial statement so that the positions can be put into one pretrial statement. And then the pretrial statement will be reviewed by both parties and filed no less than 5 business days before the hearing. Every statement must be signed by each party or counsel. However, if the parties are self-represented and there's a history of domestic violence, the parties must file separate statements. And then let's just look at the timing again for the notice of issues. That's due 20 days before trial, but the pretrial statement is due 5 business days before trial. And there's a lot that goes into the pretrial statement. You describe the nature of the action, each party's name and address, if not confidential, the name and date of birth of each minor child at issue in the case, any stipulations or agreements that have been reached between the parties, a statement of the uncontested facts or law, detailed and concise statements of contested issues of fact and law, your position on each contested issue. If you're seeking to enforce or modify spousal maintenance, then the amount and duration of maintenance, so the amount that you want it modified to and the duration, or if you're looking to enforce it, then what was the amount and duration ordered under your decree? What if they do, excuse me, we've got a question. What if they do not want to do a joint pretrial statement? How is that handled? Well, if the court orders it, then you need to follow the court order. If the court didn't make a specific order that you need to do a joint statement, then you could do it separately. But if we look back at the rule, go back. Unless the court orders otherwise, the parties may file joint or separate. So whether it's a joint or separate statement is going to depend on what the judge orders the parties to do. Okay, let's go back. If parenting time is at issue, let's say you're looking to modify parenting time, then you need to include what is your proposed modified schedule and indicate holidays, vacations, regular schedule. And in your pretrial statement, you could explain why you believe your proposed modified parenting plan is in the best interest of the children. You'll also need to include your list of witnesses. If there were any depositions done in the case, you'll need to indicate any deposition testimony that you intend to use. Any objections you have to the other side's witnesses and the basis for each objection. Your list of exhibits, and then any objections you have to the other side's exhibits and the basis for those objections. A general statement confirming that disclosure and discovery has been completed and that the parties have exchanged all exhibits, reports of experts, and their list of witnesses. A statement as to whether the parties have in good faith discussed settlement, and if not, the reasons for not discussing settlement. Any request for attorney's fees, and how a verbatim record of the trial will be made. A verbatim record of the trial is generally made through the court's recording system called the FTR Gold system, or there can be a court reporter. So there could be some general language in your pretrial statement indicating that the verbatim record of the trial will either be made by the court's recording system or a court reporter if the court provides one. In addition to all of those different points that you need to include, there's also attachments that need to be included. So if child support, spousal maintenance, or attorney's fees are at issue, then you need to attach your affidavit of financial information. And if you're looking to enforce or modify child support, then you would need to include a fully completed parent's worksheet for child support amount. So if you're looking to enforce, then you would include the child support order that you're looking to enforce. So the child support worksheet that shows the amount that was previously owed that you're looking to enforce. If you're looking to modify child support, then you would include your parent's worksheet for child support amount with what you want child support to be modified to. And then just keep in mind that you will not be allowed to present a witness or an exhibit other than those listed and exchanged in your pretrial statement unless the court allows you to for good cause. You waive the right to raise an objection at trial or hearing if the specific objection to the witness, exhibit, or claim is not raised in the statement, in the pretrial statement. And a party may not present an issue not listed in either party's notice of issues at trial unless the court orders otherwise for good cause. So this notice of issues and the pretrial statement, they're both really important documents because if you don't list a particular issue, exhibit, or witness, then that could get excluded at trial. Let's look at the template here for the pretrial statement. So here you can indicate if it's a joint statement or if it's a separate statement and which party you are that's filing it. And then this has all of those points that we just went over. And so this is where you're going to fill all of this information in. Exhibit, witnesses, exhibits, and you can attach additional documents to this pretrial statement with your lists. And then any stipulations or admissions, any uncontested facts, any contested issues of fact or law, a proposal to resolve the contested issues of fact and law. And then, so this is each side's proposed resolution. This statement about whether or not pretrial discovery and disclosure was completed, that you've exchanged information, the settlement statement, how the verbatim record will be kept, and then here's the mailing certificate for the document. Here's where both parties can sign, and then here's an attachment for petitioner's exhibits and any objections to respondents' exhibits. Here's an attachment for respondents' exhibits and any objections to the petitioner's exhibits. Here's a document that the petitioner could use to list out their witnesses. And then here's a document the respondent can use to list out their witnesses. All right, so we've talked about setting a case for trial, the notice of issues, the pretrial statement, and now we're going to look at the trial outline. So with the trial outline, this is a document that I've created for you, and this is something that I use in my practice. It's essentially a script to follow during the trial, but you're not required to file this with the court. In fact, you should not, nor should you send it to the other side. All right, we've got a question here. Is this the sequence? Petition to modify, request trial, list of issues, list of exhibits, list of witnesses, pretrial statement. There's a lot more in between there. That is a potential sequence, but not every case unfolds exactly that way. For example, there could be a response to the petition to modify. There can be RMC statements. There can be other pleadings filed in between there. And then you may not need to request a trial if the court sets the trial on its own. The list of issues is due 20 days before trial, so that would come first. List of witnesses and exhibits, you'll have to see if the court orders you to file that and what the deadline would be. And then the pretrial statement is due 5 days before trial. Let's look at what I've put together as a template to use for the petitioning party if you have a post-decree or post-order modification and or enforcement case. First, you'd start with your opening statement. And your opening statement is a brief statement with the names of the witnesses you will present and the issues you will address in your trial presentation. So for example, let's say you filed a petition to modify parenting time and you are your only witness. You could say something in your opening statement like, Judge, today I'm going to present evidence about why it's in the best interest of our children to modify our parenting plan pursuant to my request, and I will be my only witness today to prove my case. That's it. It's an opening statement, just giving the judge a little overview of what your trial presentation is going to be about. Once opening statements are done, and you can waive opening statement too, you don't have to do it. Then the judge will turn to the party that filed the petition that's at issue in the trial and will ask that party to present their first witness. And if the petitioning party, if they're their own first witness, then they can say, Judge, I will be my first witness, and get sworn in and then take the stand to testify. And what I recommend is that you have this trial outline, you take it up to the stand with you, and that you create bullet points within this trial outline explaining what you want to say. So just bullet points with each point you want to make so that you can stay on point and make sure you're including everything that you want to include. And with those bullet points, you can include your exhibits. So you can weave in your exhibits into this document so that it's all in a very organized and straightforward way, that the information is being presented to the judge. So let's say that you've got a case involving modification of legal decision-making. So you can see here, I have the signpost listed. Now I'm going to talk about legal decision-making for our children. And then if you have a modification case, first you're going to need to explain what has been the substantial and continuing change in circumstances. Because if you'll remember from our prior lectures, in order to qualify for a modification, that's the standard. You have to show there's been a substantial and continuing change in circumstances that merits the modification. So I've got this lined up to remind you, oh, I need to talk about what's changed. And then I also have here, I request legal decision-making be modified as follows. Explain your requested change, and then explain why your requested change is in your children's best interests. If you're seeking to enforce, the opposing party, you could say the opposing party violated the underlying order as follows. Explain the violation. And then explain what you want the court to do to remedy that violation. For parenting time, let's say you're facing a case involving a modification of parenting time. Explain how there's been a substantial and continuing change in circumstances. Explain what you want parenting time to be modified to. And this would be a good time to have an exhibit that lists out your exact proposed schedule. So I'd like to present Exhibit 1, which is my proposal to modify our parenting plan. And then you can talk about what your requested changes are and why it's in the best interest of your children. Regarding enforcement, you could present the underlying order or decree and then explain how the opposing party violated the order, present any exhibits to prove your case, and then tell the court exactly what you want the court to do to remedy that violation. If you have a case involving the modification of child support, again, you'll need to explain what are the substantial and continuing changes in circumstances, and what do you want child support to be modified to? This is where you could present an exhibit with your proposed child support worksheet showing your new child support amount that you're requesting. You can present your affidavit of financial information in support of your child support worksheet. You could present your co-parents' affidavit of financial information to support the numbers that are in your child support worksheet. And once you've admitted your proposed child support worksheet into evidence, you can start going through each number you listed in there and explain where you got your numbers from and why they're justified. So for example, in my proposed child support worksheet, I used minimum wage for my gross income because I'm currently earning minimum wage full-time. In my proposed child support worksheet, I use this certain amount for my co-parents' gross income because, and then explain where you got that number from. And you'll want to go through each part of your worksheet that you put numbers in and explain where your numbers came from. Now, for healthcare coverage for your kids, if you're wanting changes to that or enforcement, explain. If you're wanting enforcement of or changes to the child tax exemptions, explain that. If there's some sort of violation of child support or anything that was ordered to be paid related to the children, that's where you can show the underlying order, show where the other side was ordered to pay, and then explain the non-payment and what you're asking the court to do to remedy the violation. If you are facing a case involving the modification of spousal maintenance, explain what the substantial and continuing changes in circumstances are, what you want spousal maintenance modified to. You could present the affidavits of financial information in support of your request. And then if it's an enforcement action, what did the underlying order say? What were the facts that established the violation? And then what are you asking the court to do to remedy the violation? Now, for property division, you can't modify that. It's nearly impossible. There's very limited ways to do it. But in general, the property division provisions of a divorce decree are not modifiable. So we're just looking at potential enforcement there. So again, showing the underlying order, explaining how it was violated, and then telling the court what you'd like the court to do to remedy the violation. And then if attorney's fees and legal costs are at issue in your case, explain how much you incurred. You could present an exhibit in that regard, and then explain you and your co-parents' financial resources, explain any unreasonable positions taken throughout the case. You could object to your co-parents' request for legal fees and costs if that's come up. And then you would get to the conclusion of your testimony. And this is a really good place to just give a quick summary of exactly what you're asking the court to do. So overall, I'm asking this court to order the following, modify parenting time pursuant to Exhibit 2, which is my proposed modified parenting plan. Modified child support pursuant to Exhibit 3, which is my proposed child support worksheet. Those are some examples, but you would just give a brief summary of exactly what you're asking the court to do. After you've testified, you'll be subject to cross-examination by the opposing party or the opposing party's lawyer if they have one. Once cross-examination is concluded, you will be able to speak one one more time to address anything that came up on cross that you think needs to be clarified or that you would like to add more information about. So this is called redirect examination. And if you're testifying and you're representing yourself, then during cross, I would have my trial outline at the stand with me. I'd have a pen. And when things are coming up on cross that I want to testify, I want to give more testimony about on redirect, I'm going to be making some notes about that because it's really hard to remember every single point you want to make if you're just doing it off the top of your head, because it's a stressful situation. There's a lot of questions asked potentially. So I'd be taking some notes, making some bullet points about issues I want to talk more about on redirect. And then keep in mind that the judge can also ask you questions. So don't be surprised if you get one or more questions from the judge. All right. Now, if you have any other witnesses, you could call them to the stand. And then otherwise, for the responding party, you could call them to the stand as well, if there's some element of your case that you want to prove through their testimony. And if so, here in your trial outline, you list out each question you want to ask the opposing party during your case in chief. They would be subject to cross-examination. Either they would testify on their own if they didn't have a lawyer, or their lawyer would ask them questions. And then they'd get a chance to speak some more during redirect. You get to ask them questions in redirect because they're your witness in this scenario. And the judge could ask them questions. If you have any other witnesses, this is where you would prepare your questions for those witnesses. And then once you've presented all of your witnesses and rested your case, then it would be the responding party's chance to present their case. So here in the petitioning party's trial outline, this is where you would list out your cross-examination questions for the responding party and any of their witnesses. And then you've got your closing argument. I recommend starting by drafting your closing argument because it's going to help you see the story you want to tell, and then helps you draft your questions for each of the issues. You don't have to do it that way, but I find that that's a very helpful way to draft a trial outline. And again, this trial outline is just for you. It's not required. It's not in the rules. You don't file it with the court. You don't share it with the other side. This is just your script to use at the trial, so you can be sure that you are, number one, prepared, and also that you're including every question you want to ask, every exhibit you want to present, every point you want to make. That should all be in your trial outline so you don't forget while you're in the midst of the trial, which is really stressful and there's a lot going on. Let's look at a trial outline if you're the responding party. So you've got your opening statement, which, we talked about, that could be waived. And it's just a brief statement. You don't need to spend a lot of time on that. Now, the responding party, they are going to draft cross-examination questions for the petitioner on each disputed issue. So that's going to be for the petitioning party and for any of their witnesses. And then once the petitioning party has rested, it'll be the responding party's chance to testify. And so this is where, if you don't have an attorney and you're representing yourself, you would make bullet points about everything you want to testify about while it's your chance to testify. So, for legal decision making, if you've got a modification case, and you're the responding party. So let's say you oppose the petitioning party's request to modify, then you'd want to explain if this is true for your case. Again, you need to really tailor this document to your case. But if one of your arguments is that the opposing party doesn't qualify to modify legal decision making because there has not been a substantial and continuing change in circumstances, then write those points down and be sure to testify to that. Also, this is where you could explain why their requested modification is not in the best interest of your minor children. If you're facing an enforcement action and you impose the enforcement, then you'd want to explain how you did not violate the underlying order, if that's true, and why you're requesting that legal decision-making not be enforced, and and that you're asking the court to dismiss the enforcement action. So, if you agree that you did violate the order, then you're not necessarily going to say, I didn't violate it, but you'd want to explain what happened and explain why the court shouldn't punish you or something like that. So again, you're really going to need to tailor this document to your case. For parenting time, child support, really see what's at issue in your case and go through here and tailor it to everything that's happening in your case. Spousal maintenance, property division, attorney's fees. And then you could call the opposing party to the stand. You likely wouldn't. They likely have already testified, and so you don't need to. But if there's something about your case that you need to prove through their testimony, you could call them to the stand. You'll have you'll have questions for any other witnesses you present, and then your closing argument. All right, now at this point, you finished your trial. The judge has made a ruling, and the judge has ordered you to put his ruling into a proposed order and to lodge it with the court. So if that's the case, what do you do? Well, you're going to need to, first of all, identify, what's at issue in your case. If you're facing a modification of legal decision-making, parenting time, and child support, then you've got the notice of lodging, the proposed order modifying, the parenting plan with the terms of the modification, the child support worksheet showing the modified child support amount, the child support order showing the modified child support amount, and then an income withholding order. This is an order to the party that's ordered to pay child support. This is an order to their employer to take a certain amount of money out of their paycheck, send it to the support clearinghouse so that the money can then be given to the parent entitled to receive child support. So here's a sample of a notice of lodging. I only found this form in the Maricopa County forms, but it's essentially just saying, look, I'm giving notice that I'm lodging this proposed form of order. And the reason you do this is because it gives the other side a chance to object. So you lodge the proposed form of order and the other side gets to review it, and they have a certain amount of time to object if they think that the language is not accurate or isn't as clear as it could be, or is missing something. They would have a chance to file a written objection if they opposed all or part of the proposed order. Let's look at the set form for the proposed order modifying legal decision-making, parenting time, and child support. So this is a 4-page form, and you'll start filling this out the best you can. So you're indicating what happened at the trial and what the court is opening or ordering as a result. So you just fill this out, and then you leave this part blank because that's where the judge dates and signs. You can attach supporting documents to this form, like a parenting plan and a child support worksheet. Here's another proposed form. This is just if only parenting time is being modified, or if parenting time and child support is being modified. So the last form was modification of legal decision-making, parenting time, and child support. But if you don't have all 3 of those at issue in your modification case, then this form could be a better form for you to use. So you'll fill this out, and then let's look at a proposed order modifying child support and or spousal maintenance. This is a Yavapai County form. You'll just fill in the name of your county here, and then fill this out. Let's say parenting time is being modified. You could use this proposed parenting plan to list all the terms of the new parenting plan, and that can be attached to the proposed order modifying as Exhibit A. And then if child support is being modified, then you would complete your child support worksheet that matches up with the amount ordered for the modified child support. And then you would attach this as, for example, Exhibit B to your proposed order. And then there's a child support order. And again, this is if child support is being modified. And this is filed separately. This isn't attached as an exhibit to the proposed order. This is a separate filing. And then here's the current employer information form. This is used in Maricopa County. And so this is the employer information for the parent that was ordered to pay child support or spousal maintenance. And then here's the Yavapai County income withholding order. So this is the form that we use in Yavapai County. And it's a 5-page document. Let's look at the proposed order enforcing legal decision-making and or parenting time. So we just finished up looking at the proposed orders modifying. Here's some proposed orders enforcing. So this is to enforce legal decision-making and or parenting time. So you would fill out this proposed order, but you would leave the date and the judge's signature line open so the judge can sign and date. Let's look at the proposed order enforcing support. So this is a Yavapai County form. You can fill in the name of your county here, but you can use this form if you're looking to enforce child support arrearages only, medical insurance coverage, spousal support, medical, dental, or vision costs, or other sums owed pursuant to a child support order. So you just fill this form out. And then let's say one of your kids has become an adult. So the child support for that child needs to be terminated. Or let's say you were ordered to pay spousal maintenance for 3 years and the 3 years is up. Well, then you would have your underlying petition would be about terminating child support and or spousal maintenance. And here's the proposed order terminating. In addition to terminating the child support and or spousal maintenance, this can be a very helpful form, which is stopping the order of assignment or the income withholding order. So that's that order to the payer's employer to take money from the payer's paycheck and send it to the support clearinghouse so it can go to the ex-spouse or co-parent. And so if the child support or spousal maintenance is being terminated, then you're also going to want to stop the income withholding order, and so that no more money is taken out of your paycheck and sent to the support clearinghouse. So here's the proposed form for the order stopping order of assignment or income withholding order. Okay, we've got a question. When is the best time to file this stop order? If I would say maybe a month or two before the amount, before the order expires, or before the amount terminates. So let me use my words a little better here. Let's say that your child is graduating from high school in May. Then I would likely file around April saying, look, they've already turned 18, they're getting ready to graduate in May. So the obligation to pay child support ends as of May 31st. And I'm asking this court to enter an order terminating. So if you even do it before or after, I'm saying before the last payment is when you would file. If you do it after, you can still do that. It's just, you might have some additional steps to seek to get everything worked out and get the money back and all of that. But yeah, I would say file before the final payments due so that it's ready, but you're not going to want to file too far ahead of time. And hopefully this is something you can do based on a stipulation with the other side, because if you can do it on a stipulated basis, which we did look at those forms when we talked about ways to reach agreements and settle your case outside of court, that's obviously the fastest way to resolve the termination of support, is when both sides file a stipulated proposed order saying, yep, this is done. Here's the proposed order enforcing the division of property. So this is about 3 pages long. You'd fill that out, leave the judge's signature page open. And that takes us to the end of today's presentation. So let's just do a quick summary. If you want your case set for trial and it has not already been set, then you want to draft and file a motion to set. When the court sets a date for your trial, you'll want to see if the court orders you to file a list of witnesses and exhibits. If so, you want to do that and comply with the deadline. The notice of issues, that's due 20 days before your trial, identifying all issues to be heard at the trial. The joint pretrial statement, you could also do a separate statement potentially. That's due 5 days, 5 business days before the trial. The trial outline, that's your script for the trial. That's just for you. You don't share it with the other side. You don't file it with the court. And then if the court orders you to file a proposed order, you would do the notice of lodging along with the proposed order. All right. I hope that was helpful. If you have any questions, please bring those to the Q&A.